I'm going to discuss briefly the FCC versus Fox television stations case, and let me start again with the disclosure, as Walter did. I wrote the cert petition in this case. I also wrote the cert petition in the global positioning satellite case. So Walter, I'm sure my former colleagues would love it if you'd like to read more of the draft of your brief to us. But with respect to this case, this is about fleeting expletives. It's the second time the case has been up to the Supreme Court. A number of television stations and others are challenging the FCC's prohibition on the broadcast of indecent material. Now, 3 terms ago, the Supreme Court held that that policy was permissible under a statute, the Administrative Procedures Act. But the court left open the constitutional question. The case went back to the Second Circuit for an oral argument and briefing on those questions, where the matter was handled by Mr. Estrada admirably and well. There are 3 specific broadcasts that are at issue in the case. The first one was in 2002, when the singer Cher uttered what the Solicitor General euphemistically called the F-bomb during a broadcast of the Billboard Music Awards. And then the following year, not to be outdone, Paris Hilton and Nicole Richie did the same thing with the F-bomb and the S-word. And then in a third incident, NYPD Blue showed the unclothed buttocks of a woman on national television. Now, as I said, after it went to the Supreme Court, it went back to the Second Circuit for a discussion of the constitutional issues, and the Second Circuit identified 2 possible constitutional problems. The first one is it said that indecency bans generally are seen as content-specific prohibitions on speech, things that focus on the specific material that is at issue, and that is generally something that receives strict scrutiny, the court's highest standard of review, the most searching type of review. However, the Second Circuit said that the Supreme Court had issued a decision called FCC versus Pacifica Foundation, which gave the government special latitude when it comes to matters that are broadcast over the public airwaves. Now, the Second Circuit, in its opinion, suggested that the rationale for the Pacifica decision had been eroded over time because of new technology and the like, but it didn't ultimately decide and get into that whole question. Rather, what it said was a second thing. It said that the FCC's prohibition was just unconstitutionally vague, that there wasn't a rhyme or reason, it said, between the prohibitions, the fines that it levied, and the ones that it hadn't, that there wasn't a real difference in the broadcasts that got fines and the ones that didn't. And so the government filed a certiorari petition that was focused on that question about unconstitutional vagueness. But the Supreme Court, when it granted certiorari, adopted actually a broader question, asking whether or not the FCC's indecency policy violates the Constitution itself under the First or Fifth Amendment. And that move, some have suggested, means that the court wants to look at the rationale for the Pacifica decision itself. The broadcasters have not yet filed their merits brief. I think one could reasonably anticipate that they will defend.
And I'm not going to be reading.
And I think one can anticipate that they'll defend the Second Circuit's rationale about no rhyme or reason. I think the open question will be how much they want to get into this. Should Pacifica be overruled or not? If they do, this case has the potential to be really quite a blockbuster.
Yeah, what is a non-fleeting obscenity? Fleeting is the opposite of what? What's the?
Carlin.
Yeah, so
That's lots of obscenities, though.
That's not fleeting.
Right?
but it's deliberative, right?
Oh,
I mean-
so inadvertent is, I mean, what is fleeting a synonym
Not
for?
in that-
Seriously, it's like, I understand a number of obscenities, but they talk about a fleeting obscenity instead of a non-fleeting obscenity. And
Well, first, no one is talking about obscenities, but which everybody would...
expletive, I'm sorry. The word
Yes,
is expletive, right.
and it's not profanity and it's not obscenity, and it's indecency. And the question is whether the single utterance of a curse word can be sanctioned by leveling fairly steep fines per affiliate on each of the networks. And part of the problem is that the FCC takes the view that you have to beep them out every time they occur, even in news broadcasts, and even if you're covering a live event, such as a sports game
or a panel discussion,
or a panel discussion.
ACS, right?
And in fact, one of the tough moments that the FCC lawyer was at the oral argument was that C-SPAN Radio, which is a broadcast station, covered the argument, and all three members of the Second Circuit were cursing a blue streak. And at some point, one of them asked the counsel for the government, we have C-SPAN broadcast. Every judge on this panel has said things that people normally don't hear judges say. It is clearly relevant to the context. Are you going to go after C-SPAN? And the counsel for the government went, that was only the tip of the iceberg.
Thank you.